So now the trial's going to start, and what usually happens is sometimes the judges come out onto the bench and they handle a lot of evidentiary matters and motions before the trial gets started. So motions are when lawyers are coming in to say comments on the evidence, or this kind of evidence should be excluded, or this person shouldn't be allowed to testify for whatever reason. There's a million different reasons that a lawyer might make a motion, but basically that's how the case starts usually, is the judge asks if there's any motions that need to be heard, and there will have been deadlines and papers would have been submitted prior to that. Lawyers would get up and argue their motions. Sometimes the judges decide what evidence is admissible almost right before you get started. Pretty much if the lawyers agree on there might be 100 exhibits and the lawyers agree on 80 of them, the judge will say those are admitted. So you don't have to go through the process of admitting evidence as you go. In other cases, judges want the evidence to be submitted as you go through the testimony. What I'm trying to say is there's administrative things that sometimes happen at the beginning of the trial that is usually between the lawyers and the judge, or if you're representing yourself, the judge might ask you if you have any motions that need to be heard, which you would have submitted in a timely manner according to the court rules. So after that happens, it's time to start your case, and that usually starts with an opening statement from both sides. And an opening statement is where people, you or your lawyer, if you're representing yourself, it's you, and if you're not representing yourself, it's a lawyer, and they get up and they say to the judge what the evidence is going to show. And it's not really an argument. It's like the evidence will show that, Mrs. Jones has been a stay-at-home mother for all these children's lives, and sometimes they'll go through the statute and they'll kind of say how they think the evidence is going to come in, that she's the one who takes them to the doctor, and she's the one who is on the PTA, and she's the one who does this, and he's been a business person, he's been traveling, he's never been home, the kids barely know him. My client needs alimony or spousal maintenance, and here's why. So basically it's going to tell what the evidence will be, and that evidence is usually has been pre-submitted in the lawyer's trial brief. So you might submit a trial brief if that's recommended in your particular jurisdiction, or there's no trial brief and there's just opening statements, or there might be both. Here's the key. Whatever's in your trial brief or whatever's in your opening statement is not evidence. Evidence is only what's testified to or what's admitted into the court record in a proper legal fashion by following the court rules. So you can say anything you want in an opening statement, but the judge is going to listen because it gives the judge an outline of where this is going to go, but it's not evidence. I didn't testify. I don't have any personal knowledge. I'm just the conveyor of the information. So after the opening statements go, then here comes the testimony, and the evidence starts being submitted to the judge. So usually what happens is the petitioner or the plaintiff, however they characterize it, the person who filed the case usually goes first. And so if that would be you, you would be called to the witness stand, or one of your witnesses, but say it's you. Your lawyer is going to call you to the witness stand, and you're going to go up, and the judge is going to swear you in and say, do you promise to tell the truth, nothing but the truth, kind of like they do on TV. And you're going to take the witness stand, and your lawyer will start asking you questions. And so that's called direct testimony. It's direct questioning from your lawyer. So, and that might go for a half hour, and it might go for a half a day, and it might go for a full day, depending on how complicated your case is. But that will be your lawyer asking you questions, and while they're asking you questions, they're also going to be probably showing you documents that are going to be entered into your trial as an exhibit. So, for example, if you're testifying about your husband's bank records, and the evidence is that he's overspending or something, then your lawyer would probably hand you the bank records and say, can you identify, this has been marked as Exhibit 1, can you identify that for the record? And you will probably say, this is the bank records from US Bank. And then your lawyer would say, can you turn to the entry of July 13th, 2009, and you would hopefully have pre-planned this, so you would have a sticky on that or something. And if the evidence hasn't already been entered into court, your lawyer at that point is going to offer it into evidence, and the judge is going to make a ruling on whether it's going to be admitted or not. So you need to offer it. The judge asks the other side if there's an objection. If there's an objection, there's going to be a legal argument, and then if it gets admitted into evidence, then you can look at it, and then you're going to testify from it. So that's how your testimony is evidence, and that bank record is now evidence before the court. So every single thing you want the judge to look at you need to have entered into evidence, and usually you have to testify about it, because if you just enter, a whole bunch of stuff into evidence and don't tell the judge what the significance is, the judges usually aren't going to say, well, I think I'll go through these credit card receipts and see what I can find, because they don't have time for that. So you want to make sure that if you want to draw the judge's attention to some documentary evidence, that you're testifying about it. Here's a really good example. You have kids who are getting really good grades, and then you guys file for divorce, and then your kids are having to go to their dad's house and they're kind of upset, and now the grades are starting to fall. Well, you might want to point that out to the judge and say, now that my kid has to go over there every other week, he doesn't get his homework done, because here's dad's days and here's no homework has been done. And then the judge usually takes notes and says, oh, that's interesting. When dad has the little boy, he doesn't get his homework done. So that would be an example of a document, which is a school record, entered into evidence, which has to be done properly according to the court rules, and then you testify about it and you draw the judge's attention to it. And the best way to present evidence in most cases, what I always do is page label everything. Point being, you want the judge to be easily able to find stuff in your evidence, so that when you're testifying, the judge isn't up there like shuffling through papers and I can't find it, counsel, and it just slows down the process. So you put your case on. It's going to be you, it's going to be the witnesses that support your case. It might be your family at this point, it might be your neighbors. Sometimes, for example, there might be a doctor or a therapist who doesn't want to come in and testify, or they're too busy or something. So you can send a subpoena, and the court will enforce that subpoena and make that person come into court. And so but you kind of usually pre-plan that. So you'll put on your witnesses, you'll make sure all of your evidence is admitted, all your papers, all your bank records and emails and things that you want to have admitted. After you've done your direct examination, which is where your lawyer has all of your information put before the court, the other side, then the lawyer gets to cross-examine you. And you really want to practice with your lawyer about this, because cross-examination is where they try to poke holes in your story. Well, and it's all yes and no kind of question. Isn't it true, Mrs. Jones, that you don't even know where your kid goes to the dentist? Can you please turn to exhibit number 27 and look here? You say, for example, isn't it true that your husband takes those kids to the dentist, Mrs. Jones? No, he never takes those kids to the dentist. Well, could you please turn to exhibit 27, page 5, and look at that dentist record there? And isn't it true that it says there, children at the dentist with their father? So that's not true, is it, Mrs. Jones? Your husband does, in fact, take these children to the dentist. That's kind of how cross-examination goes. So you want to be really prepared, and you want to be very careful that you've worked hard with your lawyer so you can anticipate where these problems are going to be. And you want to be very careful to tell the truth, because you don't want to look bad. You don't want to say he never does. Some lawyers will tell you to say things like, to the best of my recollection, I don't remember him ever taking the kids to the dentist. Then if they pull that record out, you don't look like you're lying. You look like maybe you forgot. But at any rate, that's what cross-examination's like, and you're going to have to work with your lawyer a lot on that to figure out how to be best prepared for cross-examination. So then after you testify and you're cross-examined, typically your lawyer might be able to get up and ask you some clarifying questions, so that if something happened that needs to be clarified in front of the judge, she can get that cleared up. So after that, then your witnesses go on, and then your witnesses are cross-examined, and same thing happens. They try to find documents or places or depositions that you've given to try to show that you're not being honest, or that your witnesses are not being honest. And then it's time for the other side to put on their evidence, and they put on their direct examination. And then you or your lawyer, if you have a lawyer, you can't do it. You either have a lawyer or you don't. So your lawyer would typically get up at that point and cross-examine the other side and do the same thing. So you're going to have worked with your lawyer to find places where you think there's likely to be inconsistency in your ex's testimony. So after the evidence has come in, and the other thing that sometimes happens while evidence is coming in is that the lawyers will make objections. And so there might be an objection of hearsay, which means it's a statement that was made by somebody who's not in court to defend the statement. Another objection is you can't prove that that's an authentic document, so it's an objection as to authenticity. If your grandmother told you that your husband was rude to the teacher, the judge needs to hear it from grandma. So the judge can look at grandma and weigh grandma's demeanor and think if she thinks grandma's telling the truth or not. So hearsay means you can't usually say in court what somebody else said. So your lawyer will work with you on that. So hearsay is something that's important to be aware of, and then authenticity. Those are the most common objections in family law matters. Say your husband comes in and says, well, this is a letter from the teacher, but it hasn't been authenticated properly through the proper channels. So the judge says, I'm not going to accept that into evidence because I don't know that the teacher wrote that letter. At which point, you better be ready to get the teacher to come in there and say, yeah, I did write this letter. You need to make sure that the evidence before the judge is reliable and it's authentic, and that you're not saying what somebody told somebody in the schoolyard. So after all that happens, all the witnesses are in, all of the evidence is now admitted in court because all the documents have to be available for the judge to review. The lawyers are then going to do a closing statement, or closing argument is what it really is. Now they get to argue. When they started, they did an opening statement which just says this is what the evidence is going to show. It's kind of a little bit more bland. Now they're going to do a closing argument, and this is where the lawyer tells the judge how they think the judge should perceive the evidence that's been in. And this is where you say, you can see, Your Honor, that he said that he was always there at the school, and we saw the school records, Your Honor. We saw all those daycare pickup sign in and sign out sheets, and he never once picked those children up from school, Your Honor. He says that he's, this great father and that he's always at the soccer games, but you heard testimony, Your Honor, from the soccer coaches. He doesn't even know what Mr. Jones looks like. So now you're being very argumentative and you're trying to really argue your case so that the judge sees the evidence that came in the same way that you want to have the judge see the evidence. And the other side will do the same thing. And they'll say bad things about you. And you can see why this causes people to hate each other after a trial, because you've had to really attack each other the whole time trying to get the judge to make a ruling that's in your favor.